Welcome to Exchange Chambers podcast on boundary disputes. My name is Andrew Williams. I'm one of the barristers here.
And my name's Graham Sellers. I'm also one of the BPC barristers here at Exchange Chambers.
Graham, I remember in the 1990s when the legal world seemed a very different place, you and I having a discussion in which we were both lamenting the fact that legal aid was being cut from boundary disputes. And as a result, I think we both agreed there'll be hardly any boundary disputes going to court in future years, because who in their right mind would actually pay to fund that litigation with their own money? I think we both got that one wrong, didn't we?
We certainly did, Andrew. I think we're both revealing our ages, given it's going back to the late 1990s. But yes, we did have a conversation to that effect. And yes, I think we did get it wrong. Certainly my experience is that the boundary disputes are alive and kicking. They're out there, and there's a number of clients are more than happy to actually fund them.
And it is a surprise, isn't it, when you see the amount of money that clients are prepared to fund. Your litigation running comfortably beyond £50,000 to take it to trial, often coming closer to 100,000 for what can be, on its face, a relatively straightforward boundary dispute.
Yes.
How do you find your approach to discouraging clients, if that is what you do, when you may be asked to advise on the merit of the case, and you might think, well, this is potentially a strong claim, but surely it's not sensible to be spending this kind of money on it. Do you find yourself being quite firm, or do you think that that's not really part of your job?
I think it is part of my job in the modern era, and the views, certainly the judicial reviews regarding proportionality. Certainly, I take the view that it's an issue, an important issue that needs flagging up to clients about the economics of the situation. And I often find that putting it in practical terms, do you really want to be pursuing this with all the time, cost and effort that goes into it? Or would you like a brand spanking new car? And trying to get people to understand the amount that they're likely to spend and the associated risk, I think, can be quite difficult at times.
Yeah, I think that's right. I think it will be interesting to see how the new fixed recoverable costs ties into this. You could envisage a situation in which you'll have a solicitor saying to a client, for me to advance this case properly, especially if there are arguments on adverse possession, for instance, or boundary agreements, something like that, as well as merely analysing an original conveyance. You could imagine a solicitor saying, for me to do that kind of job properly, it's going to cost £80,000 to get you to the end of a trial. If fixed recoverable costs kick in, which frequently they will do, you're going to be looking at a small level recovery.
Yeah.
Now, of course, it might be that a potential claimant will think, well, that might mean that my liability to the other side is similarly going to be reduced. So actually, I'm willing to give this a go. But it's going to stick in the craw somewhat, isn't it? If you've got somebody who succeeds on a boundary dispute case, the 2 or 3 days of trial, and then at the end there's still several tens of £1,000s out of pocket.
Yeah, I think you're right there. I think most litigators are used and well used to telling clients there's going to be a deficit of maybe 10-15% between the cost you paid out and what you actually recover. But I think you're right that in relation to fixed recoverable costs, that percentage could be considerably higher.
Yeah, and of course the value of the land that we see being argued over can sometimes literally have no value, can't it? And you'll have certainly in a domestic residential boundary dispute, you might well have a neighbour who perfectly reasonably and perfectly properly feels aggrieved at what they see as theft of their land. But what they're arguing over has probably no value. And the next thing, solicitors come on board, we come on board, there were surveyors, and we're saying, well, we need to see the original conveyance under which the land was divided. We're then saying, well, how do you interpret that in terms of what the position was on the ground at the time? You may be talking about adverse possession. There might have been an inference of a boundary agreement. And the next thing you know, this case has just taken on legs, hasn't it?
A life of its own.
Yeah. And you have a client thinking, how on earth can this case be taking up so much of the lawyer's time? It's obvious. Next door has moved the fence. Surely I've won.
I don't know about you, Andrew. Do you find clients sometimes simply say, well, Mr. Williams, at the end of the day, it's a matter of principle?
I think that's very common. And we have to be careful, don't we? Because we have to make sure the client is properly and fully advised, both of the worst case scenario, maybe more importantly, the realistic worst case scenario, plus the merits. It might be, of course, overall they should succeed. But ultimately, within our advice, we owe a duty to give the right information, to give the correct opinion. What the client then does with that information has to be a matter for the client. If the client says, well, I hear everything you have to say, but it's a matter of principle, I want to fight this. At that stage, to some extent, there's not much more that a lawyer can do other than to ensure that the client has understood the advice they've received, and then to prosecute that claim to the best of their ability.
Yes, I think that's right. Given our professional obligations, if the client has been fully advised, understand the merits and demerits of the case, I think quite clearly the professional duty is to, as you said, to advance the claim.
And of course, what we do find is that these cases often then will go off in a different direction, won't they? Harassment and trespass and families falling out for many years.
I often think that clients sometimes take quite a blinkered view of these disputes and focus on some fairly discrete element without looking at the position as a whole. Again, I don't know whether you've had this problem. I often find that clients sort of look at what's happened whilst they've owned the property in question and don't always look back and think that of a crucial nugget of evidence may be buried in something that happened 10, 15 years before they owned the property.
Yes.
And they don't always take that holistic view, sort of step back and look at everything as a whole.
What has been your impression of the experts who tend to be involved in these cases? Do you find that they do assist you for when you're advising, and that they are crucial when it comes to trial, or do you feel that maybe sometimes the parties place a little too much weight on the opinions of surveyors?
I think it varies from case to case, but as a broad generalisation, I think certainly there are cases where clients do place enormous emphasis on what the expert has said, and quite clearly the fact that in a lot of these cases each side will have their own expert means that it's one expert saying ABC and another expert saying XYZ. What sometimes troubles me, and I know there have been a number of cases touching on this relatively recently, and experts just going outside the remit of what they're supposed to be doing. And I do find that on occasion, having to sort of pull the reins and sort of say, no, that's a matter for the court. That really is not a matter for you, Mr. or Miss Expert.
And certainly what I see a lot of is clients going in the first instance to a surveyor rather than to a solicitor. They will instruct the surveyor to prepare a report, but usually they don't ask the right question.
Mm.
And you might end up with an expensive report or survey. For instance, sometimes it's you'll get a very impressive looking overview of the title plan and Google Maps, then various conclusions made on the basis of that. And then, of course, we come along and we end up saying something along the lines of, well, that's quite a useful document to help me get my head around the geography. But in terms of actually working out where the legal boundary is, it's next to useless. I also find that sometimes when you get these matters to court, you can suddenly find that the surveyors end up singing from the same hymn sheet. Certainly, I've been involved in cases like this where the experts are very far apart at first, but they do come much closer together. And I probably find that's the case more with surveyors than with other experts I come across in property litigation.
Yeah, I think that's probably right. The topic that sort of obviously flows from that, I think, is hot tubbing. I don't know whether you've had experience of hot tubbing, given that it's been with us for some time now. But I'd be interested to hear your views on that.
I haven't had that for a few years, actually. And my take on it is that probably is one area in which I'm probably still a little traditional in my practice. I think with most issues to do with boundary disputes, I try to think, well, what's a way we can take this case forward other than the tried and tested muscle memory way of property litigation? Whereas for experts, actually, I'm finding that the traditional way, if you simply get one expert, you cross-examine with the basis of having had a great deal of input from your own expert beforehand, and then the same happens on the other side. I'm finding that still produces the best results. Well, how about you?
I've got mixed feelings about that. The times I've seen hot tubbing take place. Sorry, perhaps we should have explained what hot tubbing is. And essentially, it's a situation where the judge hears from both experts simultaneously. So expert A will say, well, I think the answer is this because of A, B, and C. And rather than then being a delay of maybe a day, half a day until expert B comes along, they're literally both in the witness box at the same time. So a judge can listen to what expert A says and then go straight over to expert B and says, what's your response to that? So that's hot tubbing in a nutshell. The times I've seen it take place, it's been remarkably effective. And certainly the judges who've dealt with it in that way seem to like it, in my view. I'm not suggesting it works in every case, but I certainly I think it's got a number of advantages.
I think my experience of hot tubbing has probably been prejudiced by the fact that the last time I had a trial with that one expert witness, who fortunately wasn't my one, really was too antagonistic. And I think if you have an expert who is wanting to act almost as though they are the advocate, then hot tubbing especially doesn't work. To be fair, probably that expert is wholly inappropriate in any event. But certainly my experience was one in which there's a vociferous surveyor on the other side, and hot tubbing just got bogged down with what were the equivalent of him voicing objections every time he heard something he disagreed with.
I think that's very difficult indeed. I think the key to that is getting on top of it at an early stage. If there's counsel can actually identify if there's a risk in that regard, it's much easier to deal with that in conference X weeks before the trial than suddenly meeting an expert on the day of the trial and realising that he's going to go off in his own direction.
Well, of course, one situation in which you might meet an expert before trial is if you have a mediation or joint settlement meeting on site. And of course, those types of meetings can be expensive. You'll usually have the solicitor there, the barrister, and the surveyor, and that's on both sides. So it's an expensive day if it doesn't work out. But of course, it can be useful, can't it, if you have access to your own side's expert at that point. In fact, who knows? It might be it's at the early stage of litigation, and the expert you have access to is actually going to be a different one to the one you're going to end up with at trial a year later. But even so, that can be useful. You can have the experts providing explanations and answering questions in such a way that you think, right, I now know enough about this case to try to negotiate a settlement. And if that doesn't work, at least I've now got my head around the issues sufficiently, and I now know the geography of the land sufficiently that I feel that bit more comfortable advising between now and trial.
Yes, I suspect we've both had the same situation. It's all very well looking at plans, going back to in the deeds for 10, 20, 30 years or whatever. On a personal level, I find it enormously useful just going out, actually seeing the lie of the land. Even in the modern era with Google Earth, it's possible to look at the general location. But I think certainly for me, going out and seeing precisely what's there is invaluable. And I'm not convinced that always takes place as early as it should do. Certainly, I've had situations where, yes, the client knows the lie of the land backwards. The solicitor's been out to see the locus in early course, but counsel's only invited to sort of have a look at literally the day before trial or even on the morning of the trial.
Experience recently, which was in the context of an arbitration, and that was a boundary dispute, but it was essentially between two pieces of farmland. So the amount of land at stake was quite significant. And of course, I'd read the papers beforehand, and I could not for the life of me get my head around it, because the boundary was an unusual shape and it extended over a long distance. Of course, as soon as you turn up at site, it all makes sense instantly. You can then understand it. That was a difficult case to be involved in, actually, because I was preparing what were submissions for an arbitration, and the document, at least half the document, seemed to be primarily on the basis of trying to explain which bit of the land I was referring to any one time. So I was having to interpose photographs and the like. But suddenly thought something like arbitration. Is that something which you've considered using at any time within a boundary dispute?
I've got very little experience of arbitration. What I have found enormously useful is mediation and ADR generally, whether that's a joint settlement meeting on site falling short of mediation, formal mediation with a jointly appointed mediator. And I think that can be very useful in disputes of this nature. I think the one thing people sometimes forget with these disputes is that absent one of the parties moving away, certainly in a residential context, you've got to live with your neighbour even after it's all over.
Yes. And of course, having a mediator there does bring in somebody who is often saying to each side, not merely here are the risks if you litigate, and of course the risks that should be advised to the clients in any event. A mediator will often be able to say, this is why what you're asking for appears unreasonable to the other side.
Mm.
Now that can be useful to have your client hearing. I think that what's also useful with a mediation on site is you will have the mediator explaining the position on the ground to the other side in a way they might not have otherwise understood. So one side might be saying, we don't see all the fusses about this as a very narrow 4 or 5 inch strip of land, and yet the mediator might be the one saying to the other side, well, the reason why your neighbours are so obsessed about this is because that strip of land means they're not able to access the garage at the back, or something of that nature. So I think mediators play a very significant role here. Do you find that your clients place weight on what the mediator says?
Sometimes yes, sometimes no. I think again it's a mixed bag. Some clients will be very receptive. They'll listen with considerable care to what the mediator has said. In contrast, I think other clients are so focused that they're right. The amount of weight they put on the mediator is negligible. But I agree with you wholeheartedly. I think some mediators approach these things with a sort of knock heads together sort of type of mentality. And I think in a certain type of case, that can be really useful. What I have found with some mediations, certainly mediations tend to be long, drawn out and expensive. I don't know what your experience is. They're not always a quick fix. They can be wonderful if they work and they lead to a settlement, and then they can reduce costs. But the other side of that coin is that I think I've been involved in cases where people have mediated, it's failed, and as you say out, it's an expensive day out on a site visit. It's an expensive day if you do go to mediation and it fails.
I agree entirely. One thing that I think is always worth bearing in mind in a boundary dispute is early neutral evaluation. And certainly if you have judicial involvement in that, uh, that can be useful. Initially I was skeptical that this would work because I always felt that, especially in the context of boundary disputes, especially those boundary disputes where the client really lives and breathes the case. And when you meet them, they turn up with a legal arch file full of all documents showing their own research. I felt that on those cases, if you have a judge saying, I've heard what both sides are saying, and although I'm not the trial judge, my provisional opinion is the defendant should win this case and the boundary should be the yellow line on such a plan. I thought that you would have litigants saying, well, the judge is only saying that because they haven't spent enough time looking at the case. But actually, my experience has been more positive than that. I think that the handful of cases I've been involved in where there's been E&E, the parties have placed weight on what the judge has thought. And I think without exception, it's in my experience, it has actually led to a settlement shortly afterwards. Have you had experience of that?
No, I've had experience of E where a judge has given a provisional view, as you've said. I think the take-up rate or the success rate, again, varies enormously. But I think you're right. The mere fact that a judge has uttered words of encouragement, I think that there is merits in the defendant's case or vice versa. People cling on to those words. What troubles me, I suppose, about E&E is the amount of time judges actually get to actually look at the papers prior to the pre-appointed E&E session. I've had cases where literally the papers have been thrust before the judge 10, 15 minutes before the session. I have had cases where the judge has had literally a full day to prepare.
Yes. And of course, we've been talking in the context mainly of litigation in the courts. But of course, frequently you'll have solicitors who will make an application to the land registry to rectify the title. But what they're really trying to do, so they'll have to rectification by changing what's on the title plan. Do you have any opinions as to whether you see that as being better than going to the courts?
I don't think it's a case of either better or worse. I think it's got its role depending on the facts of the case in question. I quite agree that the mechanism and routes available to the land registry are there, and providing that the mechanics are not abused, I think it works satisfactorily. I think obviously where sometimes you do get a problem is when people go to the county court. And certainly I think all of us can remember days where these disputes were listed in front of a common law county court circuit judge who'd never dealt with a boundary dispute in his life. So clearly we now live in the days of the FTT, the first tier tribunal. But provided people look at the route they're adopting with care, and providing there's no element of abuse, it seems to me there's no real problem.
Yeah, I'd agree with that. I think the quality of judges in the first tier tribunal for this kind of work is impressive.
Yes, it's far superior to when we started in the 1990s.
Yeah, and of course you and I have been against each other being a final hearing in the first tier tribunal.
Yes.
I think one thing that does need to be borne in mind, of course, for a solicitor issuing a claim like this, is if you're bringing a claim which is a traditional boundary dispute, for want of a better phrase, under which the court is really being asked to construe the conveyance that divided up the land. Well, clearly that could be something that starts off in the court, or it might start off with an application to the land registry. But if you're bringing an alternative case, which is to say, if we lose on our primary case on the conveyance, we want to rely on adverse possession, well, then you might find you're slightly restricted if the adverse possession you're relying upon is under the new post-2002 scheme.
Yeah.
So to that extent, you might find yourself having to both issue court proceedings and an application to the land registry.
Yeah.
So sometimes that side of things needs some further thought. Well, Graham, I think we're starting to come to the end of our allotted time. I'm wondering if there's a particular lesson or thought that you have that you think might be worth mentioning to those of people can only remember one thing from this conversation.
You're restricting me to one thing. For me, I think the takeaway point, and I hesitate before calling it the golden rule, but do please look at the relevant conveyances in detail. As Andrews mentioned a moment ago, will often be the conveyance whereby the land is first transferred. And it astounds me the number of times when people have referred to that conveyance, but without reading it with care, especially the plan. I think anybody who deals with boundary disputes knows that one of the first questions you need to ask is, what is the status of the plan that's annexed to the conveyance in question? Is it there simply to indicate broadly where the land is? Or does it actually define and delineate the land that's the subject matter of the conveyance? So my golden rule, if I can call it that, is please do look at that document and please do look at it with considerable care.
Wise words. Well, I would just add as my thought to also bear in mind boundary agreements, and in particular the fact that sometimes the court will look at what's on the ground. The court will look at the original conveyance that you've just mentioned, Graham, and the court might sometimes say, well, actually, this is a situation in which what's on the ground at the moment can't be explained by the original conveyance. So therefore, there must have been a boundary agreement. And by way of a boundary agreement, the court will often infer one. And that means our court might say, well, we haven't heard evidence of witnesses who say that they reached a particular agreement, that the boundary should be moved, but we're prepared to infer it for various reasons. And of course, that type of inferred boundary agreement binds successors in title. So I think that's something always worth bearing in mind, just something for practitioners to always think about in these cases. Well, Graham, I think that's us done.
Well, thank you for your time. I've enjoyed the conversation as always.
And thank you for people out there who have joined us for this. And we hope to maybe see you sometime in the future.
Thank you.